Do you believe that the banks lent too much money to the property and construction sector?
I do now, yes.
Do you accept that you had the power to impose lending limits through the concentration ratios applying to the banks?
Well, I think we had powers to intervene. Maybe not necessarily through the sectoral concentration limit, but I think we did have the power to set ratios. And, you know, I would never try and defend ourselves by saying we didn't have the power. I think we could have interpreted our powers. I think, you know, if the authority was of the view that an intervention was necessary, we could have found a way. Now, admittedly, I mean, the argument would probably be in the authority that, you know, those rules were more focused on the affairs of an individual bank. That if somebody was kind of out of line compared with all the others, well, this is how you'd intervene. That you'd, you know, use your powers to deal with one bank. But what was happening here was everybody was in the same boat, and you know, it quickly, I think, this thing shifted its boundary out of the micro area more into the macro area and into the kind of financial stability dimension.
But in essence, are you accepting that the financial regulator had the tools and the powers to put a brake on the extent of lending by the banks to property and construction?
I think there were tools available to us that if we had sat down and worked them through and considered them in the context of needing to do something, we would have found a way. I wouldn't argue against you that there weren't tools available.
And Mr. Neary, the central bank and regulator sent about 80,000 pages of documentation to the banking inquiry, which have been gone through forensically. And on the issue of the concentration limits, for example, extensive correspondence was available between the financial regulator and the banks. The concentration limits were breached in a number of cases, as you know. There are letters on file from the banks essentially stating their case that they felt the risks were acceptable and asking the regulator to go away. The summary that we have of the correspondence on sectoral limits: 2003, no conclusion in the documentation; 2004, no conclusion in the documentation; 2005, no conclusion in the documentation; 2006, no conclusion in the documentation. There seems to have been a distinct lack of follow-up by the financial regulator in dealing with that issue of the banks lending too much money to property and construction, despite you having the explicit and direct tools to do so.
Yeah, I saw that's in the core documents, and you know, there was a lot of correspondence. I wouldn't have been aware that all of this correspondence was going on, but that's beside the point. It was going on. Now, I think that serves to illustrate, I think, the difficulty that people had with the interpretation of the sectoral concentration limit, and that the arguments that were coming back and forth. And for example, I think in that correspondence, it illustrated, you know, some of the ways in which there was a way around the sectoral concentration limit. I mean, banks who had their head offices somewhere else and had subsidiaries here could quite easily transfer the risk out of this jurisdiction back to head office by an internal risk transfer mechanism and get around it. But it just illustrates, I suppose, the way in which mechanisms can be used to manage, I don't know what word you use, but to kind of minimise the impact of the.
But Mr. Neary, the inability to reach a conclusion and to follow through on that, does that also illustrate a failure of regulation?
I think it does. I think I have to say that we had an opportunity with that sectoral concentration limit, rather than letting it fall into abeyance and get into all this back and forth correspondence. We had an opportunity at least to look at that limit. Now, it seemed to be unworkable in the way it was expressed and the way in which it was interpreted, but we could have at least, I think, taken the opportunity to visit upon that that guideline and see was there ways in which we could segregate some of the riskier sectors out and put a limit on that. We did not do that, and that I regret that.
And on the broader issues, Mr. Neary, just to clarify, you aren't citing a lack of powers as regulator as a reason for
I'm not
dealing with
because
issues.
I think that I think that, you know, when push came to shove, the regulator, if it had set that limit and had, you know, even powers or no powers, I think, you know, if it had really set a hard, well-defined limit, I think we would have been able to I think, bring some control onto the situation.
Okay. You state in your opening statement that the supervisory measures introduced by the authority were not sufficient to meet the challenges posed by the crisis and the recession that emerged. And can I ask you, Mr. Neary, in hindsight, what do you think are the most important things you should have done and would have done differently as CEO of the Financial Regulator?
I mean, I have to say that I was a practitioner of principles-led regulation. I bought into that. I think the authority, as well as regulatory authorities all over Europe, bought into that. And I think we had great expectations that a combination of the legal requirements about capital and so forth, plus responsible behaviour from boards and management would contribute to a stable financial system. That clearly didn't happen. So with the benefit of hindsight and seeing what has happened throughout Europe, it was, I think, necessary to have a far more intrusive regime of supervision, where we I think were tough and, you know, adjudicated much more rigorously of what was happening in the bank.
You said on page 9 of your witness statement, I do not think, even with the benefit of hindsight, that the authority in the context of the time would have assumed a different approach to supervision. People would regard that as a remarkable statement, Mr. Neary.
Yeah, I was trying to set that in the context of the time, right? When principles-led regulation was, if you like, the accepted practice throughout Europe. I mean, clearly that's not the case now. So I'd like to maybe correct that possible misinterpretation of what I meant.
What is the essential reason why no sanctions were imposed on banks, credit institutions during your tenure?
In relation to the prudential area, I think it was a matter of conflicting priorities and resources, and and it's not an excuse because it worked in other departments of the regulator, but the administrative sanctions regime was quite a demanding structure to put in place because it had to be be absolutely fair in all its proceedings and procedures and arrangements, and it could have been contested all the way up, I think, to the court at the end of the day. So it had to be very fair and it had to be very judicious, and there had to be rules and all the rest of it. So it was a big job of work.
What happened, Mr. Neary?
Well, it did happen. It did happen in the across the regulator. It most certainly did, and there was
no actual
enforcement
sanctions against the banks.
Not in the prudential area. We never got that established properly because of the competing priorities coming from other work within banking supervision.
But Mr. Neary, is that not like bringing a suspect before a criminal court and the court doesn't have the option of sending the person to prison and they're released back onto the street, and what will they do? They will reoffend because there's no sanction.
No, I'm just trying to explain what happened. I'm not trying to defend it or excuse it. Of course, when we had the structure in place to put in the sanctions, of course, they should have been put in. Now, the authorities' view, though, was that there was a lot of merit in continuing the ongoing arrangement and the contacts between the regulatory people and their counterparties in the bank to deal with governance and compliance issues. That was the right thing to do on the prudential side, and that the focus of the administrative sanctions should be more towards compliance with the codified arrangements for consumer protection.
We had evidence yesterday from Mary Burke, who was the head of banking supervision from 2006. Under questioning, she said, "We were not able to pursue administrative sanctions cases because of a lack of resources." Is that accurate?
Yeah, I wouldn't disagree with that at the time, that the resources in banking supervision were extremely thinly spread. And I think, I think that was why I think the authority, was of the view that, okay, park the administrative sanctions for the moment in banking supervision on the prudential side, and let the ongoing relationships deal with that, and let banking supervision concentrate on the implementation of Basel, which was a huge project. I couldn't overstate how big that project was at the time.
The request for additional resources by Ms Burke in May of 2008 was supported by her immediate superior Mr Con Horan, but was not ultimately implemented. Where did that fall down?
Yeah, I have just a couple of little reminders here, because there's you don't have a reference in your just deputy there in your core documents.
No, it's in her statement yesterday, Mr Neary.
Oh, sorry, yeah. No, because I think I have just made a few notes of that myself that might just help me. Just give me 1 second.
No, it was yesterday's evidence.
No, but okay. In anticipation of this issue maybe coming up, I just jotted down a few notes to help my recollection, but I just want to find them. Just bear with me now for 1 second, please. Yeah,
Horan indicated that the issue went to the Remuneration and Budgeting Committee.
It certainly did.
Of which you were a member.
That was the procedure. That each year there was an extensive budget process that we undertook. So each department had to set out their budgets in detail and submit requirements for further resources and that. I mean, we shared our services with the Central Bank in a lot of cases.
Do you remember this particular case, Mr Neary?
Well, I remember it. Yeah, I do.
What happened?
What happened was, well, there's a process. I have to describe the process briefly. That each manager of the various departments made submission in relation to the required resources, and brought them all together, and then it formed part of a presentation of a case to the Budget and Remuneration Committee. And I would attend that committee, and it would usually be accompanied by both the Prudential Director and the Consumer Director when we would be meeting the committee on these matters, because obviously they had to argue the case for their resources. That year, we came up with a figure for new staff of, I think it was 77 people, 70-something anyway, it was in the 70s, across the entire organisation, okay? And certainly, the head of banking supervision was looking, I don't remember exactly how many she was looking for, but she was looking for six. What happened was, when we went up with the 77 to the Budget Remuneration Committee, I mean, they were kind of quite taken aback, I suppose, because, this was a huge figure. It seemed to be consistent with the strategy process that we had gone through not too long before, so where did the figure come from? And there was a lot of argument and discussion. It was a combination of new work that we had got, and also vacancies and pressure on existing staff. The long and short of it was that, yes, I'm sorry, I don't mean to use up your time. The long and short of it was that the authority approved 25 staff, right? And they gave me some discretion about how that staff should be allocated. Now, I think an extremely important fact in all of this is that the Central Bank, the HR department of the Central Bank, recruited all our staff for us. And to be fair to them, they used recruiting agencies, they put ads in the paper, they had stuff up on the web. We could not get people to come to work in the Central Bank. So much so that every month during 2008. We had the Deputy Director General of the Central Bank, who was responsible for providing recruitment services, coming and briefing the authority on his efforts.
Whatever about the ability to actually recruit people, was the request for 6 additional staff by the head of banking supervision in May 2008 sanctioned or not?
It was sanctioned.
Fully sanctioned.
It was sanctioned within the 25 people. I had that discretion. And there was never any pushback from the authority. Really, they never said, no, you can't have resources.
Mr. Hurley's statement that any request for additional resources by the Financial Regulator was never refused, is that accurate?
Yeah, I think that's accurate. But Mr. Hurley, the service that Mr. Hurley's people had to provide to us in that instance was to get the people for us, and they weren't able to do that. So the question, I think, I can understand Mrs. Burke's frustration, but it really wasn't anything to do with the authority not approving her 6 people. It was that you couldn't get them. Yeah.
Okay. So do you believe that you fulfilled your duty under Section 7 of the 2003 Act, where you, as Chief Executive, had the same power as the Board to appoint employees as you consider necessary for the effective performance and exercise of the functions and powers of the bank in each of its constituent parts?
Well, yes, in the sense that one can only use, the extent of human endeavour to provide those resources. And I think why that clause was put in there was that if there was identified a particular position in the regulator that might fall outside the norms for grading structures and all of that, that gave the Chief Executive power to recruit a person outside those structures. I think that's why it was put in there.
Mr. Neary, can I put to you some of the central conclusions of Professor Honohan in his official report on the regulatory approach? He says it was and was perceived to be excessively deferential and accommodating, insufficiently challenging and not persistent enough. It meant not moving decisively and effectively enough against banks with governance issues. Corrective regulatory intervention was delayed and timid. There was a pattern of inconclusive engagement with regulated entities on prudential matters and a lack of decisive follow-through. Do you accept that?
Well, I think as a general assessment of principles-led supervision, it's very, very, very hard to argue against it.
Not a general assessment of principles-led supervision, Mr. Neary. It is an assessment of your application of regulation during your tenure. Well, that's what it is.
Well, I think we'll have to agree to differ on that, Deputy, because I think the authority took the view that the principles-led supervision regime was the appropriate one, and it clearly did not deliver the desired outcomes. So, in that sense, the conclusions in Professor Honohan's report, I think, it condemns the system.
But Mr. Neary, where in the principles-based regulation does it say that the regulator should not move decisively and effectively against banks with governance issues? Where does it say that the regulator should be excessively deferential and accommodating, that the regulator should be insufficiently challenging? Where does it say the regulator should not be persistent enough? Where does it say that?
That's a fair point. It doesn't say that, and I thought in our earlier discussion, or hoped in our earlier discussion, that we clarified some of the challenges and the issues that we had to overcome. And I think that the I accept that the system of regulation, that if you will, allow those elements to develop.
Mr. Neary, how would you describe your professional relationship with the Governor of the Central Bank, John Hurley, during your time as CEO of the regulator?
I describe it as constructive and cordial.
In his report, Governor Honohan notes that pressure was exerted on the Financial Regulator, can you comment on his view that the Financial Regulator acted in a deferential manner towards the Department of Finance in regard to proposed legislative changes, and he cites compliance statements, fit and proper requirements, etc. Can you characterise the relationship between the Financial Regulator and the Department of Finance?
Well, the main relationship with the Department of Finance, I think, was reflected in the DSG, the Domestic Standing Group. That's where most of the contact would have happened. There was some contact on those matters that you mentioned. There was contact with the Department of Finance in relation to the Director's compliance statement, to the best of my recollection.
Can I ask you about pressure from the industry, the banking industry, Mr. Neary? How extensive was there lobbying by the industry of you personally and your senior executives on the approach to regulation, on specific regulatory issues affecting certain institutions?
No, not affecting certain institutions. Most of the representation that would have come would be by way, I think, of observations and discussions at the industry panel, which was the statutory consultative panel that was set up to represent the views of industry towards the regulator. And they met, I think, every month, and represented a broad spectrum, I think it was every month anyway, and represented the broad spectrum of interests. And I had fairly regular meetings with the chairman of that, and they did comment extensively on the work of the regulator, and they did, set out certain areas where they would have expected the regulator to act.
Can I put to you, Mr. Neary, some of the evidence from Mary Burke yesterday, again, on this issue? And I'm paraphrasing, but she painted a picture of senior executives at the regulator's office meeting bank executives behind the backs of the employees of the regulator who were directly regulating those banks. She painted a picture of meetings on the 7th floor involving very senior people at the regulator with those bank executives, which she said was a cause of tension, that at its most benign indicated a disconnect between banking supervision department and senior regulatory executives, and it seemed to sap morale. Did that happen?
I don't know what period Mrs. Burke was referring to. In the last few months before the crisis, there were regular meetings held with banks, and the governor organised a lot of those. He led the meetings, and at short notice I could have been asked to attend those meetings, and I would. And in those circumstances, I would have gone along and maybe not have notified anyone in the Bank Supervision Department because I called in at short notice. But as a general rule, when banks were coming in on pre-arranged visits to the regulator is to deliver their annual results or whatever, if I attended that meeting, I would certainly have been accompanied by the Prudential Director or somebody else, and the briefing would be prepared. But they would be the regular kind of contacts. But in the exceptional contacts that took place towards the end of 2008, I think maybe Mrs. Burke has a point. But I wouldn't consider that would be, there was no, if you like, practice set out to do that or to go behind her back. I think I wouldn't accept that.
Mr. Neary, when did you first become aware of Sean Quinn's contracts with difference exposure in Anglo?
Can I talk about the client of...
It was dealt with yesterday afternoon in the inquiry, so I can give you some guidance on that.
Yeah, please, Chairman, just...
In a general matter, you certainly can, Mr. Neary.
In context of what is already in the public domain, for example, there is a book by Simon Carswell, Anglo Republic, which claims that sometime around late September 2007, Mr. David Drum met you at your office to tell you about Sean Quinn's investment in Anglo-Irish Bank and the concerns that Anglo's board had about it. Did that happen, for example?
No, there was a meeting. I had a meeting with David Drum at some stage around September, and David Drum came to me and said, did I know anything about CFDs, that he had a sense that there was some activity in CFDs, and he suggested there was rumours out there that Sean Quinn was active in the CFD market, and he kind of said, look, I'm not able to get any information, do you know anything? And we didn't at that time, other than the rumours that were circulating.
That was in September.
That was
2007.
in September 2007, absolutely, yeah.
And Sean Quinn's name was mentioned to you specifically by Mr. Drum at that stage in the context, possibly, of holding contracts with difference in Anglo-Irish Bank.
Possibly, I think, as a suspect of Mr. Drum, if I can put it that way, that he was wondering, was there any truth in Mr. Quinn holding CFDs? Had I heard that thing? He was coming down and he came down on his own informally to kind of tease this out to see had I any insight about that.
Did you look into it further at that stage?
Yeah, well, I tried to kind of make some inquiries, with colleagues that regulated the broker side of the house, but there was nothing other than the rumours around the place. Nobody had anything hard and fast about Mr. Quinn and his CFD.
And when did you first establish facts?
The facts were established, I think it was on Good Friday, which is around the 24th of March in 2008. Now, I haven't got the facts of this here in front of me, but and I'm relying purely on memory, so I haven't got the dates precise. Yeah, you'll have to excuse me.
Meeting between you and Mr. Quinn in January 2008?
There was a meeting in January 2008, but he said that he had small CFD positions, and I remember a phrase that stuck in my mind that he was now long in financials or something that he took, but he certainly didn't give me any impression, and I didn't feel, this matter. If he had CFDs, I mean, that's a matter for Mr. Quinn. And he volunteered that he had some CFDs and that he had now gone long in financials. And I took him to mean, I took him to mean that whatever CFDs he had in financial stock, that he had converted it into a holding insurance.
And when you first learned of this issue, are you satisfied, Mr. Neary, that you took the adequate and appropriate steps to assess the significance of it and the possible impact it might have on the stability of Anglo-Irish Bank and a wider financial system?
Well, when we got the full facts on the 24th of on the Good Friday.
7 months from September 2007 to March 2008, did you take adequate steps to get to the bottom of the issue?
No, well, I had absolutely no information. The only thing that was out there was rumour, and I didn't.
You had the CEO of a bank at your door.
A little bit more time in
September
September, but I'll bring you back in at the end of questioning as well.
I'm just making the point, Mr. Neary. You had the CEO of a bank in your office in September 2007 bringing this issue to your attention.
Well, it wasn't quite as direct as that. He came into me and he was trying to see if there was any way we could establish, or did I know anything. And he said he would continue his investigations, and I said I would make my inquiries. And I think, met or spoke to Mr. Drum. I had contact with Mr. Drum either on the phone or I met him at some time, and nothing had emerged on that to quantify it or to give any kind of credibility to the fact that there was a huge CFD position built up in Anglo.
Deputy McGrath.
Thank you, Chair. Mr. Neary, was there consensus at board level of the CB, FSAI and the Financial Regulatory Authority about the regulatory approach with banks? Was there ever any difference of opinion expressed between the two?
No, there wasn't.
Thank you. What role did the Financial Regulator play in the preparation of the Financial Stability Report every year?
I would suppose we would be the providers of data and information in relation to the activities of the banks and their loan books, etc. So it would be very much contributing the information, and in that regard, the assessment, the analysis, the adjudication was done by the economics people.
But was it a joint report ultimately?
Yes, it was, in the sense that the final report and the message from the report was determined from a joint meeting of the authority and the central bank boards. The two boards came together to agree the message of the Financial Stability Report.
So, Mr. Neary, when you described earlier on the central bank's assessment in the Financial Stability Report as being overly benign, should that be not our assessment?
Insofar as, yes, there would have been buy-in to that from the Financial Regulator, I think that's a reasonable observation.
Just to be clear, Mr. Hurley in his witness statement stated the central bank agreed the content of the Financial Stability Reports with the Financial Regulator. In the foreword, for example, of the 2007 report, he said this report reflects the joint views of the bank and the Financial Regulator. Did you essentially sign off on the Financial Stability Report every year?
Yes, the authority did that at a joint board meeting of the Central Bank Board and the authority, yes.
Okay. Well, do you think in any sense that until now in your evidence you might have sought to deflect some of the responsibility in terms of the Financial Stability Report entirely onto the central bank and not reflected the joint nature of that report, which is clearly evidenced in Mr. Hurley's statement and in the report themselves?
Sorry, Deputy, I had no intention of deflecting blame anywhere on anybody.
I'll give you an opportunity to express your view, because earlier on you were referring a number of times to their assessment and the central bank's assessment. The reports were clearly joint reports.
Well, I suppose it's maybe then it's to describe a process. What would have happened is that a final position would have been arrived at, and that position, that's where the financial stability people from their research would present a position, and it would be taken on from there by the joint boards, and they would discuss that position and see whether they could agree with that and endorse it. If they didn't agree with it, well then I imagine that it would have to go back and be reworked.
I suppose the key question that arises from that is, did you also miss the financial stability risk posed to the financial system by the lending practices of the banks?
Well, the risks posed by to the financial system by the practice of the bank, by the banks, was, I suppose, a combination of factors. First of all, it was the overconcentration on property lending, which in the years 2009 was decimated by the fall in the values of property. But before that, the solvency liquidity issues were also a contributory factor.
It's not a very direct answer, Mr. Neary. I mean, for example, the 2007 report published in November 2007, Financial Stability Report, concluded, the overall conclusion is that the Irish financial system's shock absorption capacity remains robust and the system is well placed to cope with emerging issues. November 2007. Yes. You signed up to and presumably concurred with that conclusion. So my question again is, along with the central bank, did the financial regulator miss the financial stability risks posed to the financial system by the lending practices of the banks?
Well, it certainly understated those risks. There's no doubt about that.
The question of resources, was it open to you as CEO to reallocate your existing resources from, say, the prudential supervision side, where you had 210 people in 2007, to the banking supervision side, where you had 48 people in 2007?
Well, you see, each department was compartmentalised, and every department would argue, hence the 77 people that we looked for in 2007, that the resources were stretched. Take, for example, the insurance department, where we had a reinsurance directive and the Solvency II directive to be implemented, which was broadly equivalent to Basel II. So in circumstances like that, those departments also had huge work demands on them. And, but I did have discretion that if there was a surplus in one area to move to the other. But I just have to qualify that because it was a question of skill sets as well as available people.
One final point, Mr. Neary, and I think it's important from an evidential point of view. Mr. Horan's statement yesterday that he made formal proposals in August 05 for higher capital charges for high loan-to-value mortgages were not accepted, as they were not considered by senior management in the CBFSAI to be necessary. Subsequently, they were implemented in 2006. But can you just clarify, they were not accepted by whom?
They were accepted by me.
Okay.
I took it forward to the Chief Executive, and I proposed that the proposal should be taken to the authority because it was a very, very significant and well-argued proposal. I believe that the Chief Executive consulted with the then Director General of the Central Bank to discuss our proposal, to discuss the issue. And I believe that they came to the conclusion that interest rates were likely to increase and that we should wait and see, with the increase in interest rates, take the heat out of the market.
So at that time, in the autumn of 05, those proposals didn't make it to the level of the board?
No, they did not get to the authority, to the best of my recollection. They were reactivated again in either January or February 2006.
Yeah. Thank you, Mr. Neary.